Good morning to all participants of the Paris Arbitration Week, or good afternoon or good evening, depending on where you're joining us from today. This year, Paris Arbitration Week looks quite different to what we usually I used to see it like, but the silver lining is that we were able to gather great speakers and also the audience that is from all over the world, and the people who were not necessarily going to attend Paris Arbitration Week this year had it been in an offline format. My name is Marina Zinkova. I'm an associate with White & Case in Moscow, and I'm also a member of the committee of the Young Division of the Singapore International Arbitration Center. The name of our webinar today is Recent Developments and Key Arbitration Trends in Asia. And we thought that it would be interesting to speak about arbitration in Asia during the Arbitration Week in Paris, which is one of the main European centers of international arbitration. And we wanted this webinar to be just a general overview of several Asian jurisdictions, and we hope that it would give you some thought-provoking information about arbitration generally and how it works in different parts of the world, and just maybe will allow you to get to know Asia a little bit better. I encourage the audience to ask questions. You can do it by typing your question in the Q&A field, and I will read out your questions to the speakers if we have time for that, but I do apologize in advance if we don't have enough time for all the questions today. So we are going to speak about 5 Asian jurisdictions: China, Hong Kong, India, Korea, and Singapore. And let me introduce our speakers. We have Manish Agarwal, who is a partner in 3 Crowns in London, and he is an English solicitor and an Indian advocate. We have Darrell Chu, who is a partner in Sherman & Sterling in Singapore, and Darrell is also my fellow member of the committee of the Young SIAC. Edwina Kwan is a partner at King & Wood Mallesons in Sydney. Edwina is qualified in Hong Kong and in Australia and specializes in China-related disputes. We have Seonmin Lee, who is a partner at Peter & Kim based in Seoul. And we have Pei-Ching Ong, who is a partner at TSMP Law Corporation in Singapore. So to start our conversation today, I want to ask the speakers to give a brief overview, general overview of their respective jurisdictions. And I want to start with Darrell. Darrell, what are the distinctive and most important features of Singapore arbitration landscape in that jurisdiction?
Thanks, Marina. Good afternoon, everyone. And good morning to those of you in a different time zone. Well, the typical features of an attractive arbitration seat, I think, will be familiar to many of us. Users have a spectrum of needs and generally want to select a seat with modern legislative framework that respects the party's choice of arbitration, facilitates recognition and enforcement of awards, and limits court intervention, an independent judiciary that's competent, efficient, with expertise in arbitration, as well as legal expertise within the jurisdiction and a meaningful right of representation, whether it's by counsel within or outside the seat. Now, all of these are critical to selecting a seat, and Singapore is known for these features. But in the next few minutes, I will focus on 3 other attributes of a seat that will be increasingly valued by users in today's environment. Now, what are some of the most pressing concerns today, not just of users of arbitration, but of businesses globally? Our world today is characterized by COVID-19 pandemic concerns, a more uncertain and volatile geopolitical landscape, increased polarization and nationalism, And put yourself in the shoes of a business owner in this context. Where do you want your disputes resolved in the longer term? Now, I think three attributes of a seat will be key: security, stability, and sustainability. So on security, in the wake of the pandemic, subsequent waves of infections, increasing incidents of protests in some jurisdictions, I think users will prioritize seats that are best able to address their health concerns and guarantee safety and security to all participants in the arbitration process, whether it's counsel or witnesses or arbitrators. And practically, this means a reliable health system, a track record of successfully containing the pandemic, and also factors like easy accessibility and continued operations of judicial functions. And I would say these concerns extend not just to security of the person, but also online security. So technological infrastructure to protect data and to safeguard the increased use of virtual communications against cyber attacks. On stability, I think users will be inclined to select a seat which offers a stable business environment, predictability, neutrality, and which is not frequently entangled by political skirmishes that could affect the perceived fairness or impartiality of the system supporting arbitration. And finally, sustainability. There are a few different aspects to this, but users will value trusted government and trusted systems, which are adaptable and resilient and have a track record of working through different crises. From an ethical perspective, the seat should be supportive of professional and other norms governing the behavior of arbitrators and counsel, which embrace a diversity of cultural and legal traditions, and innovation and diversity. I think users have eschewed the one-size-fits-all model, and the seat and its institutions should embrace a culture of innovation and diversity of dispute resolution options, and continually invest in improving and meeting the needs of users. Now, coming back to Singapore, I think Singapore has demonstrated many of these features and is well placed to continue to serve as a global dispute resolution hub. On security, thankfully, we have managed to contain a pandemic with reasonable success. We have a well-resourced health system. The daily cases have come down significantly and measures are in place to manage subsequent waves. Our judicial functions have remained operational throughout this period, and technological infrastructure and online security remain key priorities. On stability, Singapore is known for its stable business and political environment. Its neutrality within Asia has contributed to its popularity, and it's vindicated by the SIAC statistics, which show new records year after year in 2019, with parties from almost 60 jurisdictions choosing to arbitrate at the SIAC with a total sum in dispute of about $8 billion, which is about 15% increase from 2018. And on sustainability, Singapore has embraced innovation, from third-party funding to regular updates to its International Arbitration Act, which we will discuss later. Singapore presents a diverse range of dispute resolution options that includes our international commercial courts as well as our International Mediation Center. We hosted the global signing of the Singapore Mediation Convention and established the Maxwell Chambers facility, which is Asia's largest fully integrated dispute resolution complex. I think the SIAC itself has pioneered various innovations, including the cross-consolidation protocol, and SIMC has promoted online mediation and developed a COVID-19 protocol. So one final very quick point on geography. I think pre-pandemic, the debate tended to center on globalization, but there is now an increasing premium placed on physical proximity. Whether it's regionalization of supply chains and operation, physical proximity now matters. Singapore sits within a region with tremendous growth opportunities in the next decade. We are in the backyard of Indonesia, Thailand, Myanmar, Vietnam, Philippines, all countries which expect significant foreign investment and economic modernization. We're a stone's throw away from China and India, and we maintain strong relationships with these countries. So in summary, I would say few jurisdictions can boast this blend of security, stability, and sustainability. coupled with acceptability across the East and the West. And I think all of these factors have contributed to Singapore's popularity as a seat, especially for disputes with a nexus to Asia.
Thank you, Darrell. Pei-Chin, I'm sure you will want to add something to what Darrell has just said.
Yes, thanks, Marina, and good afternoon or good morning to everybody as well. Thanks, Darrell, for the introduction of Singapore. I think it's captured the essence of why Singapore is attractive as a seat for arbitration. Just to add on to his point about infrastructure, with the pandemic, while we are in the midst of a pandemic, infrastructure may, on the face of it, matter less, I think, to parties, because a lot of it is going to be done online. But even so, the SIAC has a lot of experience in doing that. Just 2 weeks ago, I completed an international arbitration evidential hearing over Zoom, and parties and witnesses were in various jurisdictions: Hong Kong, Thailand, Singapore, and it was all very smooth. I think the tribunal and the parties were very well supported. There was also live transcription at the same time in all the jurisdictions. So I think Singapore is still continuing to be going to be very well placed to do this. We have adapted quite quickly to doing arbitration in this new way. And just being in this region still helps because of the time zone differences being of minimal concern. So I'm going to just zoom in on sort of a more micro level issue. So Singapore is also quite well known to be a very efficient place to resolve disputes. I think Darrell has already mentioned some of the statistics for the SIAC. I'm just going to touch very briefly on 2 procedures that the SIAC rules provide for, which help to facilitate the efficient resolution of disputes. So one of it is the expedited procedure. This is where the dispute can be resolved very quickly in certain circumstances. The final award is meant to be rendered within 6 months of the constitution of the tribunal. And the criteria is like this. The first is that the amount in dispute does not exceed $6 million, that's Singapore dollars. The second is that the parties agree to expedite the arbitration. And the third requirement is that it's for cases of exceptional urgency. So usually, if the dispute does not exceed Singapore dollars, 6 million Singapore dollars, it's quite likely that the claimant is able to expedite the procedure. The other procedure that will help the efficient resolution of disputes is the early dismissal of a claim or defense. That's sort of the equivalent of summary judgment in court hearings. So when a claim or defense manifestly does not have legal merit, or the claim or defense is manifestly outside the jurisdiction of the tribunal, then we can apply for the claim or defense to be dismissed, and usually it's resolved within 60 days of the filing of the application. And I'm just going to touch very briefly on the third point, which is that in Singapore, there's minimal curial intervention. I think it may not be the same in all other jurisdictions, but in Singapore, the courts are very supportive of arbitration. So they have a policy of not interfering with the final awards too much. It's quite difficult for people to challenge the jurisdiction of the tribunal who heard the case, or to set aside the final award. So as an example, last year there was a case which is BTN and BTP. In that case, the court repeated a warning of the Court of Appeal a few years ago that in light of the limited role in arbitral proceedings, the court must resist the temptation to engage with what is substantially and appeal on the legal merits of an arbitral award. So the context was that the defendants were owners of a group of companies, and they were bought over by the plaintiff. And at the same time, they also entered into employment agreements where the clauses that set out what they would get if they were terminated with cause or without cause. The difference basically was that if they were terminated without cause, then they were entitled to payment of US $35 million. So I think just a few months into that arrangement, they were given notice of summary dismissal with cause. What the defendants did was not to initiate arbitration proceedings right away. What they did was to go to the Malaysian Industrial Court for a ruling that the termination of the employment was without cause. And because the plaintiff did not participate in the proceedings in that case, the Malaysian Industrial Court ruled in favor of the employees, the defendant employees, that the termination was without cause. Subsequently, the defendant employees also initiated arbitration proceedings to claim that US $35 million that they say that they were entitled to. Now, the first question that the tribunal then had to grapple with was whether that Malaysian Industrial Court ruling was a decision that would bind the tribunal. So whether there were issues which were already res judicata. In the end, the tribunal ruled that it was so. So the plaintiffs could not reopen the question as to whether the termination of the employment was with or without cause. Now, the plaintiff then brought originating summons to the court to challenge this ruling based on jurisdiction. They say that this was in effect a negative jurisdiction ruling, and the court did not accept that. In fact, the court had very harsh words for the plaintiff. They say that the courts have time and again cautioned against the creativity of parties in crafting their arguments based on an alleged breach of natural justice. And the same caution applies to jurisdictional challenges. A challenger may stretch the concept of jurisdiction in an attempt to shoehorn his dissatisfaction with an arbitral award into a jurisdictional challenge in order to seek a de novo review of a tribunal's decision. So I will just end here. So sorry about this.
Thank you, Pei-Ting. Just picking up on what Zhao and Pei-Ting have said about Singapore and how all institutions work together to provide first-class dispute resolution services in that jurisdiction. I just wanted to share my experience of 2014 when we were invited to a presentation in Moscow where Singapore was presented as a place of arbitration and generally as a dispute resolution jurisdiction. And there were representatives of SIAC, SICC, the Ministry of Foreign Affairs, the Ministry of Law, the Supreme Court. And it was just amazing for me how representatives of all these different institutions can come together to promote their jurisdiction. And it kind of gives you a sense of how it works generally in Singapore and gives you kind of trust in the jurisdiction and that everything will be done to provide the most effective dispute resolution possible. And just going back to the great examples that Pei-Ting has given on the minimal intervention on the part of state courts, I think that it's actually undisputable that the pro-arbitration jurisdictions need to strike this balance between minimal intervention and maximum support on the part of state courts. And I know that there have been some developments in this regard in India, so I just wanted to give the floor to Manish to tell us about them, and also just generally, what do people need to know about arbitration in India?
Thank you, Marina, and hello everyone. It's a real pleasure to be a part of this webinar. So what are the most distinctive features of India as an arbitration seat, and how does it perform against the various criteria that Daryl and Beijing have identified? And I think the starting point is the legal framework, the national arbitration legislation and the judicial practice. And I want to kind of look at that and actually, without looking at other factors, just focus in the first part of my presentation on the legal infrastructure. And I appreciate that a lot of our audience members will be familiar with the Indian landscape, but just as a brief recap, if you look at the national arbitration legislation, which is called the Arbitration and Conciliation Act 1996, it is based largely on the Untitled model law. The legislation has been amended twice in 2015 and 2019, and these amendments are quite significant, and I'll return to these later. In terms of the scheme of the act is kind of split into two parts. Part one of the act applies where the place of arbitration is in India, and there are certain provisions where, for example, you need court-ordered interim relief, which will then also apply to any international commercial arbitrations that are seated outside of India. And this part of the legislation, part one, contains default rules in terms of the relationship between the courts and the tribunals, the doctrine of separability, competence, interim relief, and set aside. And it becomes quite significant in practice because the Indian arbitration landscape is still dominated by ad hoc as opposed to institutional arbitration. So the default rules in part one of the act do come into play quite often as a matter of practice. Part two of the act is primarily concerned with the recognition and enforcement of foreign arbitral awards that fall within the scope of the 1958 New York Convention, and it also deals with the ability of Indian courts to refer a party to arbitration where there is an arbitration agreement providing for a foreign seated arbitration. Importantly, India has made reservations regarding commerciality as well as reciprocity that is contemplated in the New York Convention, and reciprocity reservation can be quite important in practice. And again, I'll return to that when we talk about enforcement. So that's the black letter law. What about actual practice? Now, first thing to note, and as Marina mentioned, is that in recent years, all three wings of the Indian state, the legislature, executive, and judiciary, have taken extraordinary efforts to develop India as an arbitration-friendly jurisdiction. However, the global perception, unfortunately, remains that recent measures are well-intended, but not always well executed, and that India does need to do a lot of spade work before it can truly emerge as an arbitration seat. Daryl mentioned that when it comes to choice of arbitral seats, user perception plays an equally important role as objective facts. And in fact, in preparing for this webinar, I asked an in-house counsel with considerable experience in India to share his experience of the Indian arbitration market. And he said that there's one word that could encapsulate the state of Indian arbitration law. And that word that was offered was uncanny. It's a good word. Its dictionary meaning is strange or mysterious, or impossible or difficult to explain. For example, as things stand today, he said, if you ask somebody a very simple question as to what is the precise legal regime that applies to your arbitration or an arbitration related court litigation, you will not get a simple answer. You will get an answer entailing a mind-boggling analysis with a very complex flowchart that goes over 3 pages. And And let me, just to kind of bring that point home, let me just try and demonstrate that by attempting an answer to that question. And again, the purpose of me attempting that answer is not to kind of engage in a criticism of the Indian arbitration landscape. It is to demonstrate how the prevailing confusion really detracts from principles of certainty, efficiency, and predictability that Daryl mentioned, which are quite important to the choice of an arbitral seat. So, you know, if somebody asks the question, well, what is the law that applies? You first ask, well, when did the arbitration proceedings in questions commence? If the proceedings were commenced on or after 30th August 2019, it's an important date because this is the date on which the most recent amendments in 2019 came into force. The arbitration proceedings are governed by the 1996 Act, as amended in 2015, and as subsequently amended in 2019. Well, what if the arbitral proceedings were commenced before 30th August 2019? You then ask a further question. Whether or not they were commenced on or after 23rd October 2015, that is the date on which the 2015 amendments came into force. If so, then the arbitral proceedings are governed by the 1996 Act as amended by the 2015 Act. It is unclear whether the 2019 amendments would apply. And there's again kind of conflicting High Court jurisprudence in that and lack of clarity in the law and in the Supreme Court jurisprudence. Well, what about arbitrations commenced before 23rd October 2015? And we know that the 2015 amendments won't apply, the 2019 amendments won't apply unless the parties have otherwise agreed. And then to work out the applicable legal regime, you ask a further question, well, what is the date on which the relevant arbitration agreement was executed? And then that takes you into a whole series of questions about case law, you know, and whether it's arbitration agreement post date 6 September 2012, whether it predates that, and all of that will then determine whether Indian courts will exercise jurisdiction, even in relation to an arbitration seated outside of India. So again, it's, as I said, you know, India is of course entitled to its own indigenous jurisprudence. You know, I don't intend to add to the chorus of criticisms, but I think what it does show is that we are far from a place where two foreign parties would feel comfortable choosing India as an arbitral seat. I think the recent reforms are indeed moving in the right direction. And I think the key question for India would be whether it could become an attractive prospect for disputes involving at least one domestic party. But perhaps let me pause here and I'll be able to address some of the other features later on.
Thank you, Manish. I want to give the floor to Edwina now and ask her what does an arbitrational practitioner need to know about Hong Kong and China as a place for arbitration.
Thank you. Thanks, Marina, and thanks everyone for having me and also for your attendance across the world. So as you know, Hong Kong and China is a very fast moving jurisdiction. There's a lot that's happening there in terms of arbitration developments, and you know, there's a lot to cover. So I'm going to try and just focus on a couple of key issues that makes it distinctive to other arbitration seats. So in terms of the mainland, Chinese arbitration hearings are generally very efficient and are known for their speed. You know, typically arbitrations can take between 1 and 3 days to conclude a complete oral hearing, and a lot of arbitrations run in accordance with Chinese arbitral rules can be concluded within 6 months after the formation of the arbitral tribunal. Another key sort of interesting feature of Chinese arbitration is it's very common to have med-arb or conciliation-arb type hybrid sort of alternative dispute approaches. And so med-arb obviously is a little bit controversial, particularly for common lawyers, where the mediator also sits as the arbitrator. So the mediator, the parties typically would try to enter into some sort of mediation proceedings, and the mediator would obviously conduct those proceedings and set the agenda for those proceedings and try to get the parties to settle. And in the event that the parties don't reach a settlement within that mediation, then they would kick into the arbitration proceedings. And the reason these are controversial is some lawyers have concerns with a mediator obviously hearing a lot of confidential information relating to financials that come out during settlement, etc., and other issues that you may not want to disclose to an arbitrator. And parties sometimes think that you can't actually separate that information from your mediator brain to your arbitrator brain. So in that respect, you know, some parties may not be used to that type of approach, but they can be very efficient. They can also increase settlement opportunities, and they're very popular with Chinese parties and PRC dispute resolution. There's also some very interesting things happening with Belt and Road disputes and also the Greater Bay region. So these are obviously, you know, interesting new areas where the Chinese government has focused a lot of investment and attention to the Belt and Road and also this Greater Bay area. And and they've also set up alternative dispute and arbitration institutions to service those disputes that arise as a result of those Belt and Road issues or in the Greater Bay area. And the reason why this is interesting is because obviously there's a lot of cross-border issues that may arise with parties from different jurisdictions investing in projects along in those areas. So take the Greater Bay, for example. Obviously there's Macau law, there's Hong Kong law. Macau obviously is based on Portuguese law. Hong Kong, which is more on a UK sort of English law tradition, common law tradition, and then there's PRC law, all operating within this very small zone. And there's been a lot of discussion between arbitral institutions within those zones of how to facilitate more cross-border investment in those regions, and also how do we deal with disputes that arise in these regions and make it much more user-friendly and efficient, considering there are these three, you know, distinctive laws and three different, you know, currencies, etc. So there's some interesting things happening there. There's a Greater Bay arbitration initiative, or where there's something like 9 different arbitral institutions that are discussing these issues together, and it'll be interesting to see how that develops. Another big issue that some of you may have seen is the PRC Hong Kong interim measures arrangement that came into place on 1 October 2019. And then the first, this obviously allows for parties involved in Hong Kong seated arbitrations to get interim measures that are enforceable on the mainland against PRC assets. And so this is a really interesting development. Hong Kong is the only place where you can have an arbitration and seek interim measures directly that will be recognised in the PRC. Previously, it was very difficult to do that. So the first case that recognised that arrangement was on the 8th of October last year. And that was the Shanghai Maritime Court that enforced an interim measure on the mainland. And then since then, the HKIAC notes that they've processed about 24 applications under this arrangement. And I think there's preservation orders in respect of around 7.7 billion RMB, which is about US $1 billion worth of assets. So that's obviously also a really interesting development. Another really key feature that wasn't recognised previously in Hong Kong was third-party funding for arbitration proceedings. Previously, Hong Kong was subject to the maintenance and Chompati kind of old common law restrictions on third-party funding, and since they have been lifted since February 2019, I'm pretty sure, and so that obviously brings Hong Kong into line with a lot of other international institutions in terms of you know, placing them in, you know, in a place where parties can now consider funding for their arbitrations, and also, you know, makes Hong Kong competitive with other arbitration seats of other arbitral seats where third-party funding is now very common. So that's a sort of summary of some of the distinctive features of Hong Kong and China.
Thank you, Edwina. Just before I give the floor to Songming, I wanted just to briefly pick up on the third-party funding issue that you raised. I know that also there have been some discussions on outcome-related, outcome-based fee arrangements in arbitration in Hong Kong, and not only in Hong Kong, but if you could briefly comment on that as well. Is there well, any amendment planned in this regard? I understand that outcome-related fee arrangements are at the moment not allowed in Hong Kong and China.
Yeah, so they are allowed in China, and they're very common in China, and our experience has been that Chinese parties haven't been as interested in third-party funding because actually lawyers give such good contingency fees that they don't need third-party funding because the lawyers take the hit and act as the third-party funders. So in that respect, Chinese clients that we deal with are always looking for contingency and uplift fees in their arbitrations, and it's been a little bit of a difficulty when you're a Hong Kong lawyer seated in Hong Kong to offer those arrangements because there are restrictions on uplift and contingency fees in Hong Kong. We've dealt with it a number of different ways, and we've got advice on it before in terms of which lawyers we're staffing on PRC matters, because there is that restriction. If you're a Hong Kong lawyer seated in Hong Kong working on a Hong Kong arbitration, then you are restricted on the uplift fees. So jurisdictions where you can offer significant uplift and contingency fees without restrictions would be very attractive for a lot of PRC clients.
Thank you, Edwina. What about Singapore? Pei-Ting, do you want to comment on third-party funding in Singapore? I understand it's quite recent in Singapore as well.
Yes, it's relatively recent. In 2017, which is about 3 years ago, Singapore has also abolished making charity and funding illegal. So one of the areas which was exempted is international arbitration proceedings. So we see a lot of interest in that area. In fact, I think even for court proceedings, there's a lot of interest in expanding that, because traditionally only insolvency-related proceedings have been allowed for to do third-party funding. There's no real obstacles now for third-party funding for arbitration proceedings.
Thank you, Pei-Ting. Just to compare, Manish, what's the situation in India? I understand it's not prohibited in India to third-party funding, I mean.
I think that is, I think, what the consensus is presently, but there is no express law that either permits or prohibits third-party funding in relation to arbitrations. In fact, if you look at the Indian Civil Procedure Code and how it has been applied in certain states, that does envisage third-party funding in relation to litigation in certain states, but it's again not embedded in the central legislation. In India, you can't have contingency fee arrangements as counsel. And I think there is now some recent Supreme Court case law that suggests that where, it's not your counsel funding the case, there is no real restriction in relation to third-party funding in civil suits. I think because the issue has not yet been fully tested at the highest levels, I think most people are still being cautious, albeit you do hear about significant transactions where third-party funding is being considered. I think another factor with India when it comes to third-party funding, which has kind of huge practical implications, is that India does have very stringent laws regarding foreign exchange transfers, and again, I think that can have a bearing based on the location of the parties and the third-party funding. So yes, I think the consensus is kind of now that third-party funding is not prohibited. However, that doesn't mean that that the position is strictly. I think there is still need for either guidance from the legislature or from the Supreme Court on this.
Thank you, Manish. Now let's turn to Korea. Sungmin, what are the current arbitration trends in Korea? And also feel free to comment on third-party funding in Korea.
Okay. Thank you very much. I'm Simin Lee, partner at Peter and Kim, and I'm qualified in Korea and England and Wales. I'm very happy to be here. So since I'm the last speaker for this round, maybe I will touch upon something lighter than other people, something less serious than other people. And I need my good friend Daryl's help in this. So when you think about Korea, the jurisdiction of Korea, or just Korea in general, what pops into your head the most? And Daryl, if you have heard of these contents, just give me your thumbs up, okay? So BTS. No? Oh, okay. Blackpink? Blackpink? No? The movie Parasite or Samsung phone? Okay. So when you think about Korea, I would be happy to say that Korea is the kingdom of contents and popular IPs. And maybe it would be useful or helpful to talk about the industry of Korea and the recent trend of the industry, and then later on talk about the dispute resolution, because naturally they go together. The Korean online and offline games grew, and accounting for 69% of the country's total contents exports. K-pops and other Korean music rose 13.5% to $260 million. The value of Korean cultural contents was forecast to be worth around $64 billion in 2019. So it is a kingdom of contents, a tech-savvy, IP right-savvy place. Inevitably, there are many disputes involving IPs as well. So there might be attempts to use these invaluable contents at a cheaper price, or maybe sometimes at no cost. And some, of course, there are parties who try their best to protect and safeguard these IP rights. And recently in Korea, we have seen a lot of IP disputes referred to arbitration. And in 2019 and 2020, there have been a lot of arbitral awards involving Korean IP owner dispute. The awards have been released under the SIAC rule, ICC and KCA rules. So the recent arbitration practitioners in this Korean market has been educated, exposed to a lot of IP disputes, uniqueness, and unique features of these IP disputes. So some might say, isn't IP dispute similar to just a normal or general contractual dispute? Well, I would say there are definitely special features to IP disputes. So maybe I would use a couple of minutes rather than talking about jurisdiction of Korea, just to talk about IP as well. So when there is an IP dispute, how would you know that a party used party A's? How would you know a party used another party's IP? And Daryl again, Daryl, do you know Star Wars? Okay, thank you. So I don't think anyone would question the iconic popularity of Star Wars. It has been released in 1977, and the total revenue involving using this license, the games, animations, characters, toys, and so forth, the revenue has been accrued in 2016 up to $29 billion. So you will imagine the size of the market. So how would we find out whether a party used this IP, used Star Wars IP? Let's say there is a content of work that features two adversary forces fighting against each other in the outer space. and like characters venture into corners of this mysterious space on spaceship, and knights and a lot of aliens coming in, invading. Would you easily say that it has used Star Wars IP? Daryl? Oh, sorry, my friend. Probably not, probably not. But if the piece of work in question happened to have its characters and the character's name is both Darth Vader, Luke Skywalker, Princess Leia, Han Solo, or Master Yoda, would you say, Daryl, that it may have used Star Wars IP? There's this uniqueness in IP disputes, and recently throughout the issuance of a lot of arbitral awards under the SIAC, ICC, KCAB, the arbitration practitioners are being in Korea. We are debating and being exposed to a lot of these IP alive issues. But the IP issues traditionally has been considered to be the area for court litigation, actually, like in other jurisdictions as well. And also, but now we see a lot of sophisticated IP owners in Korea. They are not shy to use arbitration as being the dispute resolution mechanism for various reasons. In order to talk about all the pros and cons of arbitration for IP disputes, I would need another hour, so I will not do that here. But the in-house counsels, the practitioners, they are adopting a lot of they are adopting arbitration to be their dispute resolution for the IP disputes. But the issue still remains the validity of registrable IP rights. Would it be arbitrable? That issue still lingers. And I understand that my colleagues from Singapore or Hong Kong would explain this better than me, but they have recently amended their Hong Kong Ordinance and the Singapore Acts to move towards to announce and recognize, declare to the whole world that if it's related to registrable IP and the validity issue between the two parties, it is going to be arbitrable. So they have amended their act. Some people say in the market of Korea, because we are being the hub of IP disputes, we also have to amend our Korean Arbitration Act. There are these talks here, but at the same time, some also, and this is a majority view in the arbitration practitioners, that the Korean Arbitration Act has been drafted broadly enough to allow an arbitrator to decide on the issue of validity of the registrable IPs if those issues arises as a condition presence in a dispute case. So that's something that I think I would be happy to share. So is this going to be just a happy story that arbitration in Korea is there's only rainbows and flowers all over the place? Actually, it's not, because I would like to also warn that the Korean competent Korean courts, which is a competitor of the arbitration, they're also actively evolving and developing a lot. By recently, the Korean patent courts, they have heard the case first time in English, which is a very surprising changes in the Korean market. Can you imagine like a Korean judge hearing a case in English? That's something unheard of. So we are the Korean patents courts are also testing that. So our arbitration community and this institution also needs to evolve together to accommodate the needs of the users, of the IP users. Thank you. Thank you, Daryl.
Thank you very much. That was fun and insightful. I can see that we have a couple of questions from the audience. I promise we will get back to them shortly, but just conscious of time, now that we've spoken a little bit about general overview of arbitration landscapes in the jurisdictions, let us turn to the latest recent developments. And why don't we start with Hong Kong and China this time, Edwina?
Sure. So I think I probably touched on a couple of recent developments earlier, but there are more because there's obviously a lot going on in this region. So one that is quite interesting is that the Shanghai Free Trade Zone is open to overseas arbitration institutions. That measure has taken effect since the 1st of January 2020, and that basically provides that qualified foreign arbitration institutions, including those from Hong Kong, Macau, Taiwan, etc., can set up branches in the China-Shanghai Pilot Free Trade Zone special area. This measure has provided a legal basis for foreign arbitration institutions to provide services within that special region. So previously, only Chinese arbitral institutions could operate in China. And so what this has done is you can see now that there's free trade zones across China, and there's special exceptions in these particular free trade zones. And one of them in relation to dispute resolution is that the Chinese government has allowed foreign arbitral institutions to provide their services within these free trade zones. So for me, it signals an opening up of Chinese parties, you know, of the Chinese government, and also, you know, shows that there's an interest in Chinese parties doing more cross-border disputes, and that there will be more cross-border disputes in the future, and you know, they're allowing these foreign institutions to service those disputes, which is positive. Recently, China has also recently loosened its prohibition on recognising the validity of ad hoc arbitration agreements. So previously, if you had an ad hoc arbitration agreement, it was hard to enforce that in China. So recently, the PRC Supreme People's Court issued an opinion on judicial guarantees within these pilot free trade zones again. So these free trade zones are sort of like a testing ground for what may or may not spread later on into the rest of the country. And so this sort of opinion from the SPC, or the Supreme People's Court, stated that arbitration agreements executed between parties in these registered free trade zones will be valid if particular conditions are met. Now, they don't then go into what those particular conditions are, but there's, you know, speculation that that will include ad hoc arbitration. So that sort of, we're yet to see the specifics around that opinion, but there's discussion that foreign-related ad hoc arbitration agreements will be valid if they are made within this free trade zone. So that's an interesting recent development. Another development that's down more in the Greater Bay Area, so in the south of China, it has been in relation to the Shenzhen Court of International Arbitration. And this has taken effect since the 1st of June 2019. And it's sort of a revised provisions. But basically what it means is that, firstly, the number of overseas arbitrators from Hong Kong, Macau, and other sort of foreign regions shall not be less than 1/3 of the arbitrators employed by the SIAC, or the Shenzhen Court of International Arbitration. So this is seen as sort of increasing the competitiveness of that institution as an appointing agency for arbitration. And secondly, parties to arbitration proceedings administered by the Shenzhen Court of International Arbitration can agree to hold hybrid arbitrations. So what that means is you can have sort of an UNCITRAL, you can have the UNCITRAL rules that are administered by the SIAC. This provision, so that allows a party to choose one institutional arbitration rules while engaging in another arbitration institution as the appointing agency. And that has been seen as controversial in the past. So there are certain arbitral institutions that don't allow their rules to be administered by other arbitral institutions. So we'll see how that plays out. And then a final sort of interesting development in relation to Singapore. So Shenzhen and Singapore have signed a series of MOUs around smart cities, and it also includes a collaboration on cross-border dispute resolution by Shenzhen and Singapore. These were signed on the 18th of June of this year. And an important development in that agreement is that the international arbitration awards by SIAC or the Shenzhen Court of International Arbitration would have similar standing. So you can, an award from a SIAC award could be converted into an award from the Shenzhen Court of International Arbitration and be enforced in China as a domestic award. So that obviously, you know, increases efficiency and predictability of enforcement outcomes in China. and also adds a lot of value to the Shenzhen Court of International Arbitration status, and also SIAC's relationship with the mainland as well. So that's an interesting development that's only just happened sort of in the last month or so.
We also have a couple of questions for you, Edwina, from the audience. Do you think the new national law on security will have any impact on arbitrations taking place in Hong Kong in the future?
We get asked this quite a bit from clients who have concerns that the independence of Hong Kong may be compromised as a result of what's been happening there recently, and also this new security law. There's a lot being done by the Hong Kong judiciary and Hong Kong arbitral institutions to allay those fears, and I think it's that the foundations, the legal foundations of Hong Kong as an arbitral seat shouldn't be compromised as a result of these measures. But I think in terms of perception, particularly with clients that may not have, as much experience in Asia, it does count. So if they are weighing up between Hong Kong as a seat and another seat, that might be something that influences them in terms of where they want to hold their arbitration. But I think in practical terms, we still recommend Hong Kong arbitration. We still hold arbitrations in Hong Kong. We still run them. They're still running the same way they would be. You still have a very high quality pool of arbitrators, a lot from other common law jurisdictions, ex-judges, etc. The bar in Hong Kong is still very independent and very high quality. So until those institutions start breaking down, I don't see it as having a drastic impact, but I would say that the perception for people, to the extent that you can shop around for your arbitral seat, is, that's something clients are bringing up and we are seeing more of.
And another question, will arbitration become a trend in China to resolve disputes in the near future?
I would say arbitration is already a trend in China. And as I said before, that sort of mediation arbitration model is quite popular. I think most of our Chinese clients are more familiar with Chinese arbitral institutions, CTAC, BAC, SIAC. So there's a lot of local Chinese arbitral institutions that have huge caseload, and we're very busy in terms of local arbitrations, domestic arbitrations in China. So Chinese parties are very familiar with that. The thing that we find with Chinese parties when they're involved in international arbitrations or cross-border disputes, they find it really inefficient, they find it really expensive, they don't know why they have to put documents on, they don't know why they have to, put extensive witnesses on or get cross-examined. So they are not actually huge fans of international arbitration, but that's changing, I think, and the more that Chinese parties are engaged in cross-border deals, and then they're subject to sort of other foreign arbitral institutional rules, and they realise, the way that the procedure works, then they'll get used to it, and we've had positive results from clients who have had successful arbitral awards by foreign institutions. But traditionally, the SCC in Stockholm was favoured by Chinese parties, seen sort of as more neutral. But they're much more familiar with all types of arbitration and institutions.
Thank you, Edwina. So let's turn back to Korea. I know that there has been some interesting cases that Seung-min wanted to tell us about, to illustrate your points on IP arbitration that you've made.
Yes, thank you so much again. So as mentioned just a moment ago, there were many high-profile arbitral awards that has been issued in the year of 2019 and 2020 involving Korean IP owners, and some of them are featured in GAR. So, and there were some certain interesting legal issues that have been covered in these arbitral awards that may be intriguing and interesting to the smart, intelligent audience today. and also provide some food for thought. So the first topic, the legal issues that has been hotly debated and covered in this arbitral award is, first of all, like I've just mentioned, how would you be able to determine whether party A has used the party B's IP, and whether there was any infringement, whether there was any use? That would be the interesting story, the Star Wars case. And the second would be jurisdictional issue. So if party A and party B entered into a license agreement, but party B and there was an agreed scope, but party B used developed a game or another contents which is not within the scope that the parties have agreed, then would that trigger the issue of copyright IP infringement, or would that be within the scope of contractual breach, or would it be all of them? And how would you resolve that dispute? Should it go to arbitration under the license agreement, or does it have to go to the copyright infringement litigation in the relevant jurisdiction? Or maybe, just to err on the safe side, maybe it would be smarter for the both parties to commence both arbitration and litigation based on different grounds. Then if that is the case, then would it also raise the issue of lis pendens, excuse my pronunciation, if that's correct, or the issue of estoppel? There were there was all of these complicated and interesting issues that has been debated throughout the many arbitral awards issued in 2019 and 2020. Of course, the answer would be it would differ depending on the language and the scope, actually the language of the license contract, and also the jurisdiction involved. And also you have to consult, you have to go through a good lawyer to come up with a good answer. But so these are the interesting issues, the jurisdiction issues, when you always have to think about when you are going to commence arbitration or litigation, and you have to pick and choose and carefully strategize which dispute resolution mechanism you're going to go through, because it may later on be triggering estoppel issues or lis pendens issues as well. The third issue, interesting legal point would be, would you be able to get the aid of the preliminary injunction in the local courts? So for IP disputes, the interesting thing is that every second really counts. The time is really important. So you are really fighting to move quickly if there is any IP dispute. And so when it comes to the aid of the Korean courts, preliminary injunctions, I would say with comfort that yes, the Korean court would support any arbitration when it comes to the preliminary injunction. When there is a Korean IP owner and there has been certain infringement occurred in the jurisdiction of PRC in China, then maybe as Edwina covered, you may have to, in principle, you cannot get the aid of the PRC court in that regard if there is an arbitration is seated elsewhere. But at the same time, you can consider, like Edwina mentioned, there is certain treaties that has been entered between interim measures arrangement between PRC and Hong Kong, so you can also rely on that as well, and especially design your dispute resolution mechanism to put certain institution to be that dispute to be governed under that heard under that specific institutional rules. But not only that, you can also consider when it comes to, even if your dispute resolution doesn't refer to a specific institution, you can also think of creative ways, such as if there is a SIAC arbitration, and then even if you cannot get the aid of the PRC court in that regard, you can also consider converting certain interim measure orders into a Singapore court judgment and thinking of sanctioning the people involved when that person, the officials, would be entering into Singapore soils. So that's also another creative measure to consider when you want the aid of the court. One last practical tip, when we, like I've said, I would be comfortable enough to share that the Korean courts will support the arbitration, but at the same time, there are practical things that you need to consider. For total foreign partners, so foreign IP owners who want to get the aid of the Korean courts, you have to remember that at least half of the amount, disputed amount, claimed amount, should be lodged in cash. So the guarantee bonds would not work for these cases. So I've seen a lot of clients who would just give up these options because of the actual practicality. So these are the things that you may wish to consider when you're considering the jurisdiction of Korea.
Thank you, Sungmin. I want to give the floor to Manish now. Manish, have there been any interesting cases in Indian courts lately?
Thanks, Marina. And I think in the interest of time, I'll focus on two recent developments that have great practical relevance. One relates to the enforcement of arbitral awards in India, and the second relates to introduction of statutory time limits for rendering of an award in India. So looking at the trends in terms of enforcement of arbitral awards and in terms of recent developments, if you look at the enforcement of domestic arbitral awards, the most significant development is that there is no longer an automatic stay on enforcement if an award is challenged. Now, the award debtor has to separately apply for such a stay on enforcement, and this stay can then be made conditional by the courts, and conditions can include deposit of the whole or part of the award amount. So it is quite a significant improvement from the old regime where execution of an award could be halted simply by bringing a challenge against an arbitral award. Insofar as foreign awards are concerned, as I mentioned at the very outset, India has made a reservation regarding reciprocity that is contemplated in the New York Convention. But I think India has gone further than that. And some people have argued that India may well have, not complied with its obligations under the New York Convention, in that India will enforce foreign awards made in not all New York Convention states, but only in those states which the government of India notifies in its official gazette. So, although you have more than 160 New York Convention states, India has notified, to my knowledge, less than 50 states. And so to the extent that you envisage enforcement of an award in India, at the very stage of drafting of an arbitration agreement, you have to quite carefully consider your seat and ensure that, the seat is in one of those notified states for an award to be easily enforceable in India later on. Finally, insofar as the judicial approach to enforcement is concerned, there has been a sea change in the way arbitration is perceived. The Indian courts are broadly taking an extremely proactive approach to enforcement, and you can kind of often hear the mantra about minimum intervention and maximum execution. And in fact, with some aberrations in the last few months, in the last 5 years, vast majority of foreign awards have been enforced in India. And I think the real challenge is not about the inclination of the judiciary to enforce. It's simply about delays, the time it is taking to enforce. And again, it's improving, but again, there's some cases where it has taken as long as 20 years to enforce an award. So that's kind of the first issue of practical relevance. The second issue that I wanted to talk about briefly relates to time limits for the rendering of awards. And as some of you may recall, I believe it was in the 2015 Queen Mary survey that users identified introduction of time limits for the rendering of an award as the procedural innovation that would be most effective at controlling time and costs in international arbitration. And I think Indian legislature took that user demand very seriously and incorporated such time limits in the statute itself. So as things stand, in all purely domestic arbitrations, an arbitral tribunal must render its award within 12 months from the completion of pleadings, which in turn must be completed within 6 months of the constitution of the tribunal. Now, in the case of international commercial arbitration seated in India, this time limit is not mandatory, but you still have this mandatory time limit for purely domestic arbitration seated in India. Now, the parties can agree to extend the initial 12-month period by a maximum of 6 months. So you can have up to 18 months. But if the tribunal does not render an award, either within the first 12-month period or within an extended 18-month period, under the law, the tribunal's mandate will automatically terminate unless the parties apply to the courts for an extension of that time period. And in deciding such an application for an extension, the court may substitute one or all of the arbitrators. So again, the jury is still out on these statutory time limits. Some have argued that the arbitration landscape in India, which was marred by delays, absolutely needed this statutorily imposed time limit. Now others say, well, this is an excessive intervention into party autonomy in a case which is quite complex. Why is it that the parties are restricted to extending the time period by only 6 months? Why is it that they have to go to the courts, which then entails further delay? But my own sense is that in light of the recent amendments, that the time limits are here to stay, and their operation and may well provide a model for the rest of the world. We know it's a real issue in the international arbitration world, and query whether such time limits will become the norm. But those were the two developments I wanted to have.
Thank you, Manish. We also have a question from audience to you. It's about the requirements of experience to a person to be qualified as an arbitrator. So the point that is made, I guess, is that they are quite minimum. And the question is whether this leads to a reduction of a number of arbitrations seated in India and reduction of occasions where India is chosen as a seat.
Right. So my understanding is that these minimum qualifications that you require for an arbitrator were recently introduced in 2019, through the amendment, but they have not yet been notified. So they're not yet in force. And in fact, when these requirements were published, there was a furor in the community as to whether these requirements, which I think are requirements for accreditation of arbitrators by a newly formed Arbitration Council of India, which again has not yet been notified, whether these requirements were practical. And in fact, looking at these requirements, I would agree that it will significantly limit the pool of people. So just looking at what is the 8th schedule to the Act, which kind of contains a list of qualifications. A person shall not be qualified to be an arbitrator unless he or she is an advocate in India, having 10 years of practice experience as an advocate, as a chartered accountant, as a cost accountant, and so on and so forth. And again, they have various general norms. The arbitrator shall be conversant with the Constitution of India and commercial laws and labor laws, and again, I think it's quite far-reaching, and it is not clear to me whether you require all these qualifications embedded in a statute for somebody to be able to serve as an arbitrator. And I think that may well be the reason why these qualifications have not yet been put into effect, and my hope will be that they will not be put into effect.
Thank you, Manish. Let's turn to Singapore again, and I know that Darryl wanted to tell us about some recent jurisprudence, which is also interesting in Singapore. Darryl.
Thanks, Marina. So building on the earlier points about the security, stability, and sustainability of a seat, a good seat is also characterized by robust jurisprudence in favor of arbitration. And I will briefly discuss 2 recent cases this year that showcase the court's approach to the enforcement of arbitration agreements. I think they reflect a robust enforcement of the prima facie standard, which prevents a court from considering the merits of a dispute that is prima facie subject to an arbitration. And these are illustrated in two contexts. The first is insolvency-related issues, and the second, anti-suit injunctions. So the first one, it's the case of An and VTB Bank. It concerned a winding up petition, and the Court of Appeal held that the prima facie standard applied to disputes subject to an arbitration clause, even when they arose in the context of a winding up petition. The court departed from case law in other jurisdictions headed in the other direction, requiring the court to undertake a more merits-heavy analysis. And the practical implication of this is parties cannot attempt to circumvent an arbitration by commencing winding up proceedings, as opposed to bringing an action for the amount that's owing. So in short, this reinforces the obligation to arbitrate, even in proceedings that I guess were traditionally thought to engage public policy and arbitrability concerns because of their proximity to the insolvency context. The second case involves an anti-suit injunction. It's the case of Haiqiang and Singapore Technologies Marine. Again, the court held that the prima facie standard applied and observed that the enforcement of an arbitration clause through an anti-suit injunction is a corollary of the principle that the court cannot consider the merits of a matter that is prima facie subject to an arbitration clause. And there, the Singapore courts rejected the stricter standard applied in England, which is a full merits or a high degree of probability approach, and in Hong Kong, which is a strong prima facie case. So again, it's a robust enforcement of arbitration clauses, even in the context of proceedings commenced abroad, that on a prima facie assessment is in breach of the obligation to arbitrate in Singapore. So in practical terms, users who decide to seek their arbitrations in Singapore have assurance that they can reliably and consistently expect the arbitration agreements to be enforced. It's going to be difficult for parties trying to evade arbitration for whatever reason to avoid that obligation to arbitrate by seeking a different form of relief, whether it's winding up proceedings or dressing up their claim so it's premised on a different legal basis that does not necessarily engage the arbitration clause. For example, filing minority oppression proceedings in a dispute arising out of a contractual SPA that might be subject to arbitration. And all of this tends to provide predictability. I think it helps with risk assessment, and it informs strategic choices when embroiled in a complex dispute. So in short, Singapore arbitration case law, I think, continues to be characterized by minimal curial intervention, which is good. It's consistent with model law, philosophy of international arbitration, but at the same time, there is robust curial intervention in terms of enforcing and respecting the parties' agreements.
Thank you, Daryl. I understand that apart from these important court judgments, there have been another interesting developments, such as the Ministry of Law initiating public discussions on amendments to the International Arbitration Act. So, Pei-Chin, do you want to tell us what the proposed amendments are?
Yes. So in the middle of last year, the Ministry of Law has proposed 6 amendments to the International Arbitration Act and have sought public consultation on these proposals. In the interest of time, I think I will focus on perhaps 2 or 3. But generally, the amendments are to enhance party autonomy. And one of the most, I think, debated amendment is to allow a party to the arbitral proceedings to appeal to the High Court on a question of law arising out of an award made in the proceedings. This is quite significant because it's going to be an exception to the Singapore Court's policy of minimal curial intervention. Of course, the catch is that the parties have to opt in to this mechanism. So it's still open to parties to not opt in, so that the final award cannot be challenged on questions of law. It will be quite interesting to see who would actually agree to opt in on these questions. I would think that if parties opt in, it will open the door, I think, for the losing party in the arbitration to appeal to the court. So for example, the earlier case that I mentioned, BTN and BTP, I think that would be more easily framed as an appeal on a question of law rather than a challenge on jurisdiction. So I would assume that if parties opt in to this mechanism, then the losing parties will have more incentive and scope to appeal to the court. So currently, there's a very long section that's proposed to be introduced to this effect, sections 24A to 24D, and spans a few pages. There are a lot of restrictions. For example, you need the leave of the High Court, and leave will only be granted if the question of law that you're appealing on will substantially affect the rights of parties, the decision is obviously wrong, or there's a question of general public importance. The requirements sound like quite high thresholds, so I would assume that leave of the High Court will not be so easily granted. But even so, I would assume that the losing party will still try quite hard to fit themselves into these categories. The court may also order the tribunal to set out the reasons in sufficient detail if they think that it's not sufficient for them to decide either way. And of course, this might also mean that parties will take a longer time before they reach the final resolution of the dispute, because that High Court decision may also then be appealed to the Court of Appeal. The other two amendments that I'd like to touch on, the first one is to allow parties to agree to waive or limit the annulment grounds under the model law and the IAA, the International Arbitration Act in Singapore. So currently, in section 25 of the Act, parties can apply to the court to set aside an award on grounds of fraud or corruption or breach of natural justice. It's, like I said earlier, it's quite difficult for parties to be able to do so. Just last year, there was another case where parties tried to set aside the award based on fraud or corruption because one party did not disclose what the applicant said was a very important, what were very important documents, and to call a material witness, but that was dismissed as well. So if this amendment was allowed, then parties have the option to limit or waive by agreement the annulment grounds that they can rely on. This agreement can only be reached after an award has been rendered, which then leads to the question of who would agree to this mechanism if they have won already. So I would think that if this amendment goes through, it may be of limited effect, because I cannot see why a winning party in an arbitration would agree to limit or waive the annulment grounds that the losing party can rely on. And the final amendment that I'm going to touch on is the proposal to provide that the court have power to order costs in certain situations. So currently there's a lacuna in Singapore law. The court doesn't have the power to order costs if the arbitral award is successfully set aside. In those rare cases, then there is a gap because the tribunal would be functus official and they cannot render a new cost award. So this amendment would plug the lacuna in the law. In the rare situation where an award may be set aside, then the court can render a cost award. Thank you.
Thank you, Pei-Ting. I see we have a couple of minutes left, so I will read out another question from the audience. It's about the EU investment court system and whether there's a debate around it in view of the EU-Singapore Investment Protection Agreement. We are asked whether this is also a major concern in the arbitral community in Singapore, or whether it is discussed at all. Darryl, if you want to comment on this.
Thanks, Marina. I haven't personally been involved in any such debates, although I've seen a number of dialogues kind of circulating around the internet about the criticisms around this system and this new proposal, but I haven't personally kind of been involved in any of these debates.
Thanks, Daryl. Another question to Seungmin. How does Korea and the IP office react if an arbitration dispute deals with the validity of an IP title, patent, trademark? Is there a public or any other procedure to make this title invalid outside of the scope of the award? I think that it exists in Switzerland, that an award on IP rights can be directly registrable in the state register. What's the position in Korea?
Yes, first of all, the clear position in Korea is that when it comes to the registrable IP rights, the only authority to issue the validity of the registrable IP rights is with the the authorities, IP authorities and the courts, and not so. The default rule is, so in general, in principle, and when it comes to involving third parties and announcing the validity of a certain registrable rights to the entire world, it cannot be done, decided by an arbitral tribunal or just arbitral tribunal. That's the position the Korean practitioners are taking, and the major prevailing view of the Korean practitioners. Although the type that I've said is arbitrable, that I mentioned, is that if there are any certain issues and the validity of the IP rights needs to be decided as a condition, and then the arbitral tribunal is making a decision on the damage or the breach of contract or certain issues, and the validity of the registrable IP rights needs to be decided, then those arbitral awards are going to be enforced in Korea, because it involves, but there's no clear arbitral act or commentary deciding on that issue. But the prevailing view is that is going to be enforced because it involves only two parties, not announcing to the world that it is valid or not valid to the entire world. So when I suggest that it is arbitrable in Korea, that's the aspect I was addressing. But ultimately, in principle, if you're going to deal with the validity of IP rights, you have to go to the relevant IP authority.
Thank you very much. I see that our time is expiring, so I wanted to conclude this webinar by saying a few thanks. Thanks to our speakers, obviously, to finding time to join us today, and thanks to the audience and for joining us and for very interesting questions. And I apologize that we haven't had time to answer all of the questions that we've received. I also want to thank the organizing committee of the Paris Arbitration Week, and also our friends who supported this event, and I want to name them. They are the Association of Corporate Counsel Singapore, the Asia Pacific Forum for International Arbitration, the Chartered Institute of Arbitrators, the Indian Arbitration Forum, the Singapore Corporate Counsel Association, and the Singapore Institute of Arbitrators. Last but not least, I would like to thank the extremely professional team of the Singapore International Arbitration Center who made this all happen. So thank you very much, and I think we will conclude here.